Okay guys, so welcome back to our channel EduPendent Training. Today we are still discussing regarding good corporate governance. So this is came from University of Mindanao, Philippines. Actually this is for group 3. They are going to present their presentations regarding accounting governance. But before we are going to start, don't forget to subscribe, like and comment. So we have Miss Edna over here. Thank you for being here. Mr. Christian, Miss Nova, Miss Mary Chris, and then Mr. Emmanuel. So shall we start the presentations? Group 3 that we have their presentations here. The topic will be okay. Sorry, we have incomings participant. Hello, Emmanuel. Hello, Emmanuel. Hello, sir. Thank you for joining with us here. Okay, so today will be the topic for Group 3 presentations. The topic will be accounting governance. We have Miss Edna here, and then also Sir Christian. Thank you for being here. Miss Nova, Miss Mary Chris, and then Mr. Emmanuel. Thank you for being here. So 1, 2, 3, 4, 5. Thank you. Will be accounting governance. Miss Edna, what will be your specific topic or your presentation topic?
Hi, good evening. This is Edna. So my topic is all about accounting governance in terms of miscellaneous.
In terms of miscellaneous.
Yes, sir.
Okay, in terms of miscellaneous, okay. Okay, how about Mr. Christian? I guess you are still mute your.
Hello everyone, I am Christian Garvey. So I will be discussing the accounting standard of Australia
Okay.
and competition of the country.
Okay, so accounting standard from Australia. Okay, Miss Nova, what will be your part?
So hello everyone, my name is Nova Fernandez and my topic is all about impetus for Club 9 responding to corporate collapse.
Okay, clock number 9. Okay, Miss Mary Chris, how about you?
So hello everyone, I am Marcus Parda and my topic will be about the corporate law economic reform program and also the 6 principles that will be used in Club 9.
Okay, economic reform program. Okay, and then the last one will be Mr. Emmanuel. What will be your topics?
Good evening, everyone. I'm going to discuss about corporate disclosure from remuneration of executives and director
Okay.
up to the corporate, what do you call this?
Okay. Mhm. Okay, I got it. Yeah, corporate disclosure. Okay, corporate disclosure will be your part of your presentation. Okay, so group 3, you can start your presentations right now. The end. That will be all. Okay.
Good day everyone, I am Marcus Fajardo under College of Business Administration Education, majoring in Human Resource Management. Today, I and my group, which is Group 3, will tackle the lesson under Accounting Governance. And the first topic that I will be sharing to you today is the background of Corporate Law Economic Reform Program and some later developments. So the Corporate Law Economic Reform Program, or CLERP in short, was announced by Federal Treasurer named Peter Castillo in March 1997. This involves a review of key areas of regulation affecting the business and investing activity. According to the government of United States, the main objective of CLERP was to ensure that business regulation was consistent with promoting a strong and vibrant economy and provided a framework which assisted business in adapting to change. The establishment of CLERP is said to be or to have been a consequence of decision to transfer responsibilities for legislation on corporation and securities from the Office of Attorney General to the Department of Treasury. The perception was that this transfer of responsibility will generate a shift from emphasis of legal regulation to economic regulation, and this will result in a focus on economic impact of regulation law. Since the election of Labor government in 2007, regulatory reform has continued, particularly in standardizing the state and federal requirement in an effort to reduce the regulatory burden to businesses. But these reforms have not been occurred or not present under the clerk title. As pointed out to the previous chapters and lessons, one particular important recently proposed reform is the rebalancing of responsibilities for monitoring of the capital market in favor of the Australian Security and Investment Commission at the expense of ISX. The global financial crisis of 2007, which did not affect the Australian stock market severely until 2008. It highlighted the issues associated with margin lending to directors, share trading by directors during blackout periods, and other matters, which prompted reform proposals not implemented at the time of the writing. Another area that has received attention is the executive remuneration, particularly after generous bonuses were paid in the aftermath of the downturn caused by the global financial crisis. Next is the more in-depth details of the Corporate Law Economic Reform Program. The Corporate Law Economic Reform Program, or in short CLERP, was developed with the benefit of consultation with the Business Regulatory Advisory Group, which was formed in the year 1997, with the intention of providing quality feedback to the government on business and corporate law reform. The Business Regulatory Advisory Group consists of representatives from key business groups. Since 1997, 9 policy proposal papers were released as part of the Corporate Law Economic Reform Program, comprising with the following. So the first 4 papers, as well as part of the 5th paper, which are the accounting standards, the fundraising, directors' duties and corporate governance, as well as takeovers, were reflected in the Corporate Law Economic Reform Program Act 1999. While the 6th paper, entitled Financial Markets and Investment Products, that led to Financial Services Reform Act 2001, which took full effect from March 2004. This deals with the financial products, financial markets, as well as the provider of financial services. Next paper is the 7th, which entitled or specified as the Simplified Lodgement and Compliance Procedures with ISIC. This was adopted with a series of reforms taking effect from July 1 in the year 2003, and CLERP 9 was largely adopted with reforms taking effect from July 1, 2004. And the paper 8, entitled the Cross-Border Insolvency, this was implemented by way of Cross-Border Insolvency Act in the year 2008, which commenced exactly in July 1, 2008. And the last paper, which is the paper 9, entitled Audit Reform and Corporate Disclosure. Next will be the 6 key principles to be applied in CLERP. Under the heading of Economic Approach to Business Regulation, these are the 6 key principles. First is market freedom. Competition plays a key role in driving efficiency and enhancing community welfare. However, free markets do not always operate in a sufficiently competitive, equitable, and efficient manner. Business regulation can and should help markets work by enhancing market integrity and capital market efficiency. At the same time, the regulatory framework needs to be sufficiently flexible so that it does not impede market evolution and competition. Next will be investor protection. With an increasing number of retail investors participating in the market for the first time, business regulation should ensure that all investors have reasonable access to information regarding with the risk of particular investment opportunities. Regulation should be cognizant of the difference between sophisticated and retail investor in access to information and the ability to analyze it. Third will be the information transparency. Disclosure is a key to promoting a more efficient and competitive marketplace. Disclosure of relevant information enables rational investment decision making and facilitates the efficient use of resources by companies. Disclosure requirements increase the confidence of individual investors in the fairness and integrity of financial markets, and by fostering confidence, encourage investment. Different level of disclosure may be required for sophisticated and retail investors. Fourth is cost effectiveness. The benefits of business regulation must outweigh the associated costs. The regulatory framework should take into account the direct and indirect costs imposed by regulation on business and the community as whole. What Australia must avoid in outmoded business laws which impose unnecessary costs through reducing the range of products or services, impeding the development of new products, or imposing system-wide costs. The regulatory framework for business needs to be well targeted to ensure that the benefits are clearly exceeded the costs. A flexible and transparent framework will more conducive to innovation and risk-taking, which are fundamental elements of a thriving market economy while providing necessary investor and consumer protection. Next is the regulatory neutrality and flexibility. Regulation should be applied consistently and fairly across the market. Regulatory distinction or any advantages should not be conferred on particular market structures or any product unless there is a clear regulatory justification. The regulatory framework should also avoid creating incentives or any opportunity for regulatory arbitrage. The regulatory framework should be sufficiently flexible to permit market participants to respond to future changes in an innovative, timely, and efficient manner. Regulations should be designed to facilitate predictability and certainty. Last but not the least is the business ethics and compliance. Clear guidance regarding with the appropriate corporate behavior and swift enforcement if breaches occur are key elements in ensuring that market function optimally. The government is committed to the strong and effective enforcement of corporate law and will continue to provide substantial resources to the Australian Security Commission to enforce the law. Fostering an environment which encourages high standard of business practices and ethics will remain as a central objective of regulation. So these 6 key principles are useful tool for developing or critiquing law and government reforms. So next topic will be the impetus for CLERP 9 responding to corporate collapse that we'll discuss with the next reporter, which is Ms. Fernandez.
Good day everyone, my name is Novami Fernandez, and at this point I will be discussing about the impetus CLERP 9 responding to corporate collapses and the explanation of CLERP 9 reforms and the audit reforms. In impetus for CLERP 9 responding to corporate collapses, it was then discussed in the previous reporter that renewed international attention to corporate governance resulted from the collapse of 2 Americans' largest accounting governance, Enron and the WorldCom in 2001. Regulators were quick to focus their attention on any role of those companies' auditors in contributing to the collapses due to poor audit oversight, lack of transparency and accountability, or the relevant audit firms being too close to their audit clients. In the USA, it was discovered that the global accounting firm Arthur Andersen & Co. Andersen, which subsequently also collapsed under the weight of the ensuing scandal, had signed off on Enron financial reports which overstated the company's earnings by $586 million over 5 years and had allegedly shredded a large volume of Enron's documents. This was later found on appeal not to have been case. Auditor dependence is a problem from a corporate governance perspective because if a company involves the same firm in the provision of both audit services and non-audit services, such as consulting or legal services, the auditor will possibly be reluctant to provide an unfavorable audit report to management if the result is loss of the audit engagement and the subsequent loss of the substantial fees arising from the non-audit services. Despite the limited role that auditors actually perform and their very narrow obligations under law, the renewed focus on corporate governance and the importance of the auditor's role in ensuring the reliability of the company's half-year and full-year accounts warranted serious attention being given to the regulation of auditors. Also, in September 2002, the federal government released its discussion paper, Corporate Disclosure, strengthening the Financial Report 10A PDF version of this report is available at Accounting Governance 205 Framework. However, the CLRP 9 bill was introduced into Parliament on December 4, 2003, incorporating some amendments to the draft bill and immediately sent to the Joint Parliament Committee on Corporations and Financial Services for further review. The committee released its report in June 2004. The committee was generally supportive of the initiatives contained in CLRP 9 bill. However, it suggested a number of important reforms, particularly in relation to the proposed whistleblowing provisions and shareholders' participation, including a recommendation that all individuals appointed as proxy for company meetings be required to vote as directed, with CLRP 9 otherwise being limited to reforms pertaining to electronic proxy voting. On June 25, 2004, Parliament approved the CLRP 9 bill. It came into effect as the Corporate Law Economics Reform Program, Audit Reform and Corporate Disclosure Act 2004 on July 1, 2004 as intended, with the most provisions applying from that date. In general, those cases are a evident reason why CLRP 9 bill is needed in a certain company in order to avoid corruption or bankruptcy or unethical practices within the organization.
To discuss the explanation of K-CLRP 9 reforms, in this section, we identify each of the K-CLRP 9 reforms implemented. The explanation is divided into 3 parts, which is the audit reforms, corporate disclosure, and the miscellaneous. Other changes increase audit accountability by requiring that auditors of listed company clients attended the client's annual general meeting to answer shareholders' questions, extended the duty of auditors to report unlawful conduct occurring within an audited body, gave auditing standards the force of law similar to accounting standards, which had long enjoyed this requirement, reconstituted the previous professional body that sponsored the Auditing and Assurance Standard Board as a statutory authority under the guidance of the Australian Financial Reporting Council, allowed registration of audit companies. Previously, only sole practitioners or partnerships were permitted, formalized auditor competence requirements, and provided jurisdictions to the FRC to supervise and guide auditors regarding independence requirements. ASIC set out this policy in relation to the audit reform in Policy Statement 180, Auditor Registration, and Policy Statement 34, Auditor's Obligation. Other changes increase audit accountability by requiring that auditors of listed company clients attended the client's annual general meeting to answer shareholders' questions, extended the duty of auditors to report unlawful conduct occurring within an audited body, gave auditing standards the force of law similar to accounting standards, which had long enjoyed this requirement, reconstituted the previous professional body that sponsored the Auditing and Assurance Standard Board as a statutory authority under the guidance of the Australian Financial Reporting Council, allowed registration of audit companies. Previously, only sole practitioners or partnerships were permitted. Formalized auditor competence requirements and provided jurisdictions to the FRC to supervise and guide auditors regarding independence requirements. ASIC set out this policy in relation to the audit reform in Policy Statement 180, Auditor Registration, and Policy Statement 34, Auditor's Obligation. In general, audit reform is a new set of standards for audit rule to strengthen the function of auditors within the organization in order to strictly examine or inspect the various books of accounts by an auditor, followed by physical checking of inventory to make sure that all departments are following documented system of recording transactions, and it is done to ascertain the accuracy of financial statements provided by the organization.
That's all. Thank you for listening, and the next reporter will discuss further.
Hi everyone, I'm Emmanuel Jaya Arancon, third year Human Resource student from University of Mindanao. And today, I'm going to report about corporate disclosure. Have fun!
Corporate disclosure. So what is corporate disclosure? It is a communication of information by people inside the firms towards the people outside the firms. The goal of the corporate disclosure is to communicate firm performance and governance to the outside investors. Under the corporate disclosure has 6 subtopics, namely the remuneration of directors and executives, financial reporting, continuous disclosure, shareholder participation, whistleblowers, and disclosure rules. First, we're going to discuss about the remuneration of directors and executives. The CLERP 9, or the Corporate Law Economic Reform Program Act, which was enacted in 2004, was introduced to the disclosure requirements for listed companies in relation to the disclosure of informing shareholders regarding to the rate of director and executive remuneration, particularly of the link between levels of executive pay and company performance. There are major changes in Corporates Act, which requires a greater disclosure by listed companies of director and executive remuneration, both the level of remuneration and company's policy in determining remuneration. Other CLERP 9 initiatives in relation to remuneration includes a requirement for listed companies to provide shareholders with a non-binding advisory vote on the designated remuneration report prepared by the directors. And lastly, a tightening of the termination payment rules, with shareholder approval generally being required for all termination payments. This payment includes the payments arranged pursuant to the pre-employment contracts and damages for the breach of contract due to the early termination of the contract. So under the Act, company executive, a company secretary or senior manager of a company. Senior managers, it is an individual or other than director or company secretary who participate in decision making that could affect the whole or substantial part of the business or organization. He or she also has the capacity to affect significantly the financial standing of a corporation. Next topic, the financial reporting. The Act also introduced essential financial reporting reforms that requires further information that could provide the director's report or financial reporting. Under the CLERP 9, involved the establishment of the Financial Reporting Panel, which has the jurisdiction to hear and determine disputes between the ASIC, or the Australian Securities and Investment Commission, and the companies or other entities regarding the accounting treatment in annual reports. So under the CLERP 9, in terms of compliance-based reforms, there are 3 key changes. First would be the listed companies must be included in the director's report. A declaration by the directors that they had the CEO and the CFO joint declaration that the company's financial record have been properly maintained and the financial statements provide a true and fair view of the company's position. The director's reports for a listed company must include the management discussion and analysis, which contains sufficient information that the investors will reasonably require to make an informed assessment of the company's operation and financial position. And lastly, additional information which includes the entity's full year financial report to ensure a true and fair view and the position of the company. So next topic would be the continuous disclosure. One of the most controversial areas of reform under Group 9 was the changes made to the continuous disclosure regime, which requires the listed companies immediately release to the market information that could have a material effect on the price or the value affected company securities. So under the Group 9, there were two key changes relating to the continuous disclosure. First key is the introduction of the personal liability for individuals who are deemed to be involved in an entity's contravention of continuous disclosure provision, and to provide ASIC a power to issue a so-called infringement notices. So these infringement notices is against an entity but not against an individual involved in a contravention. If ASIC considers that the entity has not met its continuous disclosure obligations, the infringement notice power was introduced with a view to enable ASIC to take action in relation to less serious contraventions of the continuous disclosure provisions. Importantly, in relation to publicity, ASIC may not issue any public release relating to an infringement notice being issued against a company. ASIC may only publish a statement when an entity complies with the infringement notice, and this statement must include a note clearly stating that the compliance is not an admission of entity's guilt and that the entity is not regarded as having contravened the continuous disclosure provisions. So next would be the shareholder participation. The Group 9 introduced some important amendments to the Act. It's designed to facilitate and promote the exercise by shareholders of important governance rights, being informed of a company's activity as well as the participation in and voting at the general meetings of the company. The key amendments are the encourage companies to embrace technology. Next would be the encourage more comprehensible notices of the company meetings. Third, the improving shareholder access to general meetings. And lastly, better inform the shareholders. This requires a list company directors disclose to other directorships held in the 3 years prior to the end of the financial year to which the report relates, and the qualification and experience of the company secretary may be included in the director's report. Next topic would be the whistleblowers. Whistleblowers, as we know it, are officers and employees, contractors and employees of contractors who report contraventions or suspected contraventions of the corporation's legislation. So, victimization. Victimization may occur in many ways, such as an actual dismissal, demotion, bullying, and extractive dismissal. There is a key recommendation of a report that was enacted by a new law, which was the Public Interest Disclosure Act. Public Interest Disclosure Act simply means to facilitate the public interest disclosure and strengthen the legal protection for whistleblowers in a federal public sector. Whistleblowers. Exploring strategies for protecting of corporate whistleblowers. This issue include the ones who allowed to qualify protection as the whistleblowers. Former employees do not qualify. Whether motive should affect protection. Currently, an individual with malicious motives cannot be protected even if the information they disclose is genuine. Next, whether anonymity should affect protection. And lastly, whether a court may order of the production of the documents that reveals whistleblowers' identity. And lastly, the disclosure rules. The objective of the underlying reform is to improve the quality of information provided to the investors in securities and financial products. There were 4 key reforms that was identified. First, which should be the disclosure documents under which securities are offered must be worded and presented in a clear, concise, and effective manner. Next would be the dealing with the financial services and products. The third is to provide exemptions for the secondary sales of securities. We originally issued without a disclosure document under the Act. The basis of this amendment was no further disclosure is required if at the time securities are issued investors that would have benefit of the information that is comparable to the information that would be otherwise be available in the prospectus. And lastly, the exempting of some secondary sales of financial products. The provision also extends the existing relief that was available under the ASIC class order for secondary sales products so that the relief is available for all quoted financial products, these managed investment products. So that's all. Thank you for listening and good day.
Good day everyone, this is Edna Alderete from Group 3, a continuation of the topic Accounting Governance. Today, I will tackle about the Corporate Law Economic Reform Program or CLERP 9 Miscellaneous, in which comprised of managing conflict by financial services licenses, register of relevant interests, officers, senior managers and employees, enforcement, and proportionate liability. Managing conflict by financial services licenses. CLERP 9 introduced Section 912A1 that provides a condition on the license of the financial services licenses. Under Chapter 7 of the Act, of which affirmed that the licensee must have in place adequate arrangements to manage conflicts of interest that may arise wholly or partially. For this, ASIC expects all licensees to document their conflicts of interest and how they have dealt with them. So, a licensee or any of their representatives providing financial services in a financial services businesses should roll out their mechanism in managing conflicts of interest, such as controlling conflict of interest, avoiding conflicts of interest, and disclosing conflicts of interest, and that can be controlled through identifying the conflicts relating to their business, assessing and evaluating those conflicts, and deciding upon and implementing an appropriate response to those conflicts. The aforementioned reform was directed mainly at addressing conflicts of interest faced by so-called sell-side research analysts working for full-service investment dealers who have not clearly separated research and investment banking businesses. That became the focus for reform after a series of Wall Street scandals in 2001 that revealed a very close dependence between research and other areas of large investment banks, particularly the Enron scandal in 2001. The manipulation by the company's chief financial officer of Enron Corporation of their off-balance sheet transactions by concealing the company's debt obligations through transferring them to an offshore partnership led them to their tremendous fall, and also by the combination of more complex financial statements, more aggressive accounting techniques, massive concern for customer satisfaction, greater dependence on consulting fees of the auditing firm in which the chief auditor of Enron at Andersen, the auditing firm in which conflict of interest arise, since the chief auditor had an annual performance goal of 20% increase in sales that he favorably reviewed the work of Enron's chief accounting officer, his former colleagues at Andersen, and he let Enron employees intimidate Andersen auditors. So it became the focus of the reform as the outcome of this scandal. Register of Relevant Interest. Section 672DA require the information that includes the details of the nature and extent of a person's relevant interest in shares in the company, interest in the scheme, or interest in the fund. Details of the circumstances that give rise to a person's relevant interest in shares in the company, interest in the scheme, or interest in the fund. The name and address of a person who has relevant interest in shares in the company, interest in the scheme and funds, as well as details of instructions that a person has given about. So a relevant interest based from the regulatory guide is involved with a person's capacity to exercise a degree of influence over securities. Consequently, the concept bound to connections wider than ownership, including connections giving rise to power or control over the voting or disposal of securities. Fundamentally, a number of people may have a relevant interest in the same securities in a variety of different capacities. Clerk 9 introduced a new definition of senior manager. The concept of senior manager is mainly used in sections of the Act introduced by Clerk 9 on executive and director remuneration and audit services. Prior to Clerk 9, the Act contained two different definitions of officer. One in Section 82A, which included employees within the definition, of which nullified, and leave only one definition of officer in Section 9. Since the two different definitions create confusion in relation to the application of the statutory duties. And in terms of enforcement, the Clerk 9 Act introduced a number of important measures to strengthen the enforcement provisions of the Act, such as increased penalties in the existing section of 206B, where there is an automatic disqualification, namely conviction for an offense for a period of 5 years. Clerk 9 amends, providing courts with the power to extend the period of automatic disqualification of directors managing a corporation upon application by Australian Securities Investment Commission for a further 15 years. Lastly, in proportionate liability, the bill proposes to apply proportionate liability to misleading and deceptive conduct claims for economic loss and property damage under the Australian Securities Investment Commission Act, Trade Practices Act, and the Corporations Act, in which expedite apportionment between a plaintiff and a defendant according to the respective level of blame, with the similarity of the contributory negligence rules that states a reduction of plaintiff's compensation if their actions increase the possibility of the occurring incident. The change to proportionate liability was mainly designed to protect auditors, but applies to all professional advisors. Prior to the Clerk 9 reforms, audit partners in firms were jointly and severally liable for professional default within the firm. Hence, exhibit each partner to unlimited liability. Traditionally, auditors had an unlimited liability through professional indemnity insurance as their protection. But, after HIH insurance collapsed, the cost of insurance premium had shot up. The formation of Clerk 9 has been anchored by the scandals of big companies in the United States and in Australia itself.
A pleasant day to all of you. I am Christian Carl A. Tagok, third year BSBA Human Resource Management from the beautiful school in Davao City, University of Mindanao. And I'm going to discuss to you the accounting standards of Australia, a continuation of the Group 3 report. So standard. Standard is an important thing for a certain organization, a party, or a country to comply for them to create harmony or to create a good governance in a certain country or organization. So accounting standard is very important enable for a certain organization to know and to have transparency when it comes to the financial statement records and everything that talks about money in a certain country or organization. That is why investing in a certain standard will help to ease the hassle, and of course to easy create financial statements for a certain financial transactions. So let's talk about the accounting standard of a specific country, Australia. So Australia accounting standard they adapted or they followed the International Financial Reporting Standard. So what is International Financial Reporting Standard? So IFRS is an international financial reporting standard, set common rules so that financial statements can be consistent, transparent, and comparable around the world. They specify how companies must maintain and how companies must maintain and report their accounts, define types of transaction, and other events with financial impact. So here is the law. Here is the International Accounting Standard Board. So as what I've said earlier, that the Australian government or Australian accounting standard, they just adopt or followed some of the standards coming from the IFRS. So they didn't literally follow everything because due to the policies that Australia has, they only just follow the things that can be applicable to their country. So they just followed some of the standards. Next is the AASB issued the suite of Australian equivalent to International Financial Reporting Standard or AFRS. So by May 2014, there is a major changes in the whole standard of accounting in Australia. So of course, following those standards, there are lots of changes, most especially in how to record the waste, the process, and in the final output of a certain financial transaction. So first, previous financial statement had to provide comparative number from the previous year. So they need to compare the things that from the previous standards they followed and compare it to the application of the new standard. So second, data needed to be reworked and redeveloped in order to go along with the new adopted standard. So of course, we are now modern. So some of the records are already in the computer or the gadget. So all things should be reworked or redeveloped in order for them to follow the standards that the IFRS required for them. Next is the reconciliations between the previous and the next treatment that is required. So this adaptation create impact on the overall shareholders and stakeholders. Of course, if you will follow a good standard, then a certain organization has a lot of changes, not just on the internal environment of the organization, but also on the external environment of an organization. That is why it become more successful. Stakeholders or shareholders gain more profit or benefit from the country or the organization. So this adapted create impact on the overall shareholders and stakeholders in every company in Australia. It became more standardized, it became more organized, and most especially in Australia's economy, it will become more globally recognized and competitive. So maybe someday some of the third world country will follow what Australia did or what are the Australian standards, so they could apply Australian standard in their certain countries, like here in the Philippines. So with that being said, it enabled to reach larger markets at a lower cost. So that is a great effect of a certain standards that a certain organization follows. However, in the initial policy of amending the wording of the original IFRS meant there was still uncertainty internationally over compliance with IFRS. So one of the most important difference between IFRS and the previous accounting standard is the emphasis of the use of fair value to value assets, particularly investments and securities, in the illiquid market for many securities in the aftermath of the global crisis, like what in the situation in the Europe and United States. That is the reason why IASB was forced to compromise on its standard on the financial instrument when European banks found themselves at a disadvantage with the US banks on the recognition of the losses on poorly performing loans. So this affects the decision of Australia to follow the AIFRS standard. So they compare USA and Europe in a certain way because they see that the United States is following the standard of AFRS. That is why and it has a great impact of increasing their market or increasing their profitability and other transactions in a certain organizations. While in Europe, it loses so much profit and performing poorly. So, and I think I do believe that that is the reason or the decision why Australian government or Australian Accounting Standard Board followed the AFRS standard. Next is the American Financial Accounting Standard Board, or the AF, has been highlighted by the financial crisis. The USA had laid on a roadmap itself to adopt AFRS by 2014, but at the same time, writing this timetable and even whether there is still appetite for this reform in the USA is still under the cloud. So that is why Australia is certain enough to follow the IFRS standard, and now, as you can see, as we observe as a simple citizen of the world, we can observe that really in Australia you can gain more profit. That is why there are lots of OFWs coming from the Philippines working in Australia and studying in Australia because the standard of living in Australia is amazing. The income is also great, and the people is living with their and achieving achieving quality of life in Australia. So I think that's also the impact of following the standard or AFRS. And some of the countries are investing in Australia and being able to gain from Australia because like what I've said earlier, that Australia follow the standard and they become globally competitive, and the market is, and they are reaching market not just locally but globally. So I think that's the accounting standard of Australia. So let's now conclude the report of all of our group. So we have recently witnessed a major change in the mode of corporate governance regulation from a disclosure-based approach, which preferred companies to disclose the corporate governance policies and practices they implemented in accordance with their particular needs, to an interventionist approach, with CLRP 9 contributing to the formalization of best practices governance benchmark by the introducing or significantly enhancing substantive corporate governance mandates under the Corporations Act. In Australia, this could be achieved by converting many of the compliance reforms into replicable rules under the Corporations Act, thereby providing companies with greater freedom on tailor their governance procedure and practices by including an alternative procedure in the company's consultation of this is considered to be better suit their organizational needs. Alternatively, ASIC or ASIC could be given powers of exemptions and modification to provide relief to companies from one or more of the provisions by establishing to AISIC that such relief would be in the best interest of the company. Another option would be to adopt an opt-in procedure whereby the corporate governance rules under the Act would only apply to the company if the company's constitution is amended to confirm that the companies opt in the rules rather than the rules applying to the company unless it opts out. In Section 5 of this chapter, we discuss some additional corporate governance reform proposals that make part of the next wave of the corporate law reform in Australia, CLRP 10. But further into the future, the very mode of regulating corporate governance, disclosure based on the prescription based, may need to be subjected to review by lawmakers and regulators. So I think that ends our report, and thank you so much for listening, and thank you everyone for giving your time to learn from us, and thank you, sir, for allowing us to report and able to share our knowledge to this subject. So God bless everyone. I hope everyone is safe and magandang buhay.
Okay, so that's wrap up for today, the presentation from Group 3 regarding accounting governance. So we can start the discussion in the comment section below, and thank you for watching.